The Supreme Court just ruled in favor of a gun rights group in a unanimous decision. This ruling from the High Court is a huge help for gun rights groups who are being targeted by the anti-gun banks and other companies. The case in question? NRA v. Vullo. If you haven't heard about this case, that's okay, because today we'll be diving into the fine details of the Vullo case and dissecting what effect it has on your rights and how Chuck Schumer, the senator from New York, almost ruined the whole outcome were it not for GOA's team of lobbyists in Washington, D.C. Hey guys, I'm Phil, and you're watching Law and Ammo. But before we get into the video, I want to take a second to tell you all about GOA's first convention. That's called GOALS, or Gun Owners Advocacy and Leadership Summit. The event will be taking place August 17th through 18th in Knoxville, Tennessee, and it's free for GOA members. Visit gunowners.org/goals for more information. Okay, so now on to the case. The National Rifle Association v. Vullo was only just recently decided by SCOTUS in favor of the NRA in a unanimous 9-0 decision. But how did we get here? Well, the New York Department of Financial Services has the power to regulate almost every major player in finance in the United States, as New York is the financial center for the entire country. That makes the person who runs the New York DFS a very powerful regulator. You might remember that in 2017, NRA's carry guard was shut down by the New York Department of Financial Services. This investigation was set in motion by a letter from an anti-gun group, Everytown for Gun Safety, and the DFS superintendent, Marie Vullo. In the wake of the tragic Parkland, Florida mass murder, Governor Andrew Cuomo announced that the Department of Financial Services would be urging insurers, banks, and companies it regulates to, quote, review any relationships they may have with the NRA for reputational risk. Vullo was quoted in the same press release saying that corporations need to lead the way on positive social change and to discontinue their agreements with the NRA. But Vullo and Cuomo went further than just guidance. In fact, they actively urged companies under their regulatory preview to cut their business ties and deny basic financial services to the NRA or similar gun-promoting organizations. And behind closed doors, Vullo continued to pressure the NRA's insurers to combat the NRA and other gun groups through mafia-style tactics. In her meetings with Lloyd's of London, an insurer of the NRA, Vullo apparently presented her views on gun control and her desire to leverage her powers to combat the availability of firearms. Vullo also said that she believed Lloyd's was violating New York insurance law and that they could come into compliance and avoid liability for its regulatory infractions by no longer providing insurance to gun groups. And on May 9th, 2018, Lloyd's publicly announced its decision to terminate its insurance-related relationship with the NRA. And in addition, the NRA says that it was denied renewal by its corporate insurer due to a fear of reprisal after witnessing Lloyd's being targeted by DFS. And if any of this sounds like a story we've heard before, that's because it is. In 2013, the Obama administration launched Operation Choke Point. The idea was to pressure banks to choke off access to credit and other banking services to disfavored industries, including firearms. But keep in mind, the businesses targeted and shut down by Operation Choke Point were legal businesses. But that didn't stop the bureaucrats from several independent federal agencies from taking it upon themselves to ruin the lives of law-abiding citizens in the name of partisan politics. But what's familiar about Operation Choke Point and the Vullo case specifically is the sinister nature of how government entities put a stop to legal businesses. And so, for example, during Operation Choke Point, officials at the Federal Deposit Insurance Corporation, also known as FDIC, simply had to inform banks that a business using their services was considered to be high risk. And that was enough to get the banks to close an account, because no bank wants to deal with additional scrutiny, the audits or the investigations from their regulator. But Vullo employed this same strategy in her fight against gun groups, and it was working, as evidenced by the gleeful tweet from Governor Andrew Cuomo that read, "The regulations New York put in place are working. We're forcing the NRA into financial jeopardy. We won't stop until we shut them down." So on May 11th, 2018, 2 days after being dropped by Lloyd's, the NRA filed its lawsuit against Vullo, Cuomo, and the New York DFS, among others. The NRA brought the lawsuit in the Northern District of New York, which is the Second Circuit. The NRA was assigned Judge Thomas James McAvoy, a Reagan appointee. Eventually, the lower court dismissed all claims against Cuomo, DFS, and a selective enforcement claim against Vullo. But the lower court chose not to dismiss 2 First Amendment claims against Vullo. Claim 1. Vullo established an unconstitutionally implicit censorship regime in an effort to chill NRA's protected speech. Claim 2. Vullo unconstitutionally retaliated against the NRA for its protected speech. And Vullo argued that she was protected by qualified immunity and was just doing her job. She argued for the case to be dismissed, appealing to the Second Circuit Court of Appeals to do so via interlocutory appeal. An interlocutory appeal is an appeal that occurs while other aspects of the case are still proceeding, or when an appeal is made before claims are resolved as to all parties. Her appeal was assigned to a panel of 3 judges. Rosemary Pooler, a Clinton appointee, Judge Denny Chin, an Obama appointee, and Judge Susan L. Carney, another Obama appointee. And as expected, the Second Circuit Court of Appeals ruled in favor of Vullo. They found that she had acted appropriately in her official capacity in pressuring companies to stop doing business with pro-gun groups. And in fact, the judges said, "We conclude that these statements do not cross the line between an attempt to convince and an attempt to coerce. Rather, Vullo's statements in the guidance letters and press releases are clear examples of permissible government speech." So here's the judge's logic. The NRA's advocacy led to a backlash, and that could affect New York's financial markets, and therefore Vullo's work against the NRA weren't threats at all, but actually meant to protect the DFS regulated entities and New York residents from financial harm and preserve stability in the state's financial system. These anti-gunners will perform whatever mental gymnastics are needed to ban guns, and this is just more proof of that. And so the NRA appealed to the Supreme Court. GOA supported the NRA at both the petition stage with a brief on the merits of the case, and then again after the Supreme Court agreed to hear the case. In our brief, we argued in favor of the NRA, arguing 4 main points. First, we argued that New York's pattern of behavior demonstrates government coercions of private speech. Second, we argued that the circuit court relied on a reputational risk rationalization that SCOTUS rejected with respect to the 1964 Civil Rights Act. Third, we argued that New York's regulatory abuses in violation of the First Amendment also implicate the petitioner's Second Amendment rights. And finally, we argued that the government is increasingly weaponizing its regulatory powers to silence political opponents. Our attorneys argued that the term reputational risk was being weaponized by New York in an attempt to silence the NRA, while legitimate reputational risk was ignored entirely. Here's a quote from our brief. "By way of illustration, a legitimate reputational risk might be avoiding engaging in business ventures with persons such as Ponzi scheme master Bernie Madoff or sex offender Jeffrey Epstein. However, in those 2 cases, even after review, the banks continue to do business. Now reputational risk has taken on an entirely new meaning, to include the danger of doing business with an organization dedicated to protecting the exercise of a constitutionally enumerated right." That is a slam dunk from our attorneys. And in a very interesting turn of events, even the ACLU agreed that the NRA was in the right. In fact, the ACLU took on the NRA as a client and represented them to the Supreme Court. The ACLU argued that this case was a critically important First Amendment fight. If government officials can pressure the businesses they regulate to blacklist the NRA in New York, then officials in other states can punish other advocacy organizations in the same way, including the ACLU itself. Listen to the ACLU defend gun groups before the Supreme Court.
In this case, Maria Vullo herself and Governor Cuomo made it absolutely clear, both in closed-door meetings with Floyd's and in public guidance letters and in tweets about this case, that they were singling out the NRA not for insurance law violations. They were singling out the NRA because it promoted guns, and they were against the promotion of guns. They can advocate against the promotion of guns. They can encourage people not to support groups that like the NRA. What they can't do is then invoke the coercive authority of her office. And look at the guidance letters. She could have written an op-ed if she was, moved by the problems of gun violence, but she didn't. She invoked her statutory authority, unique statutory authority, to issue guidance letters. What are guidance letters? According to respondent, they are designed to tell regulated entities their obligations. Then in that guidance letter, what she does is go on for 4 paragraphs about how bad guns are, and then in the 5th paragraph says, in light of the above, we urge you to reconsider your relations with the NRA and other gun promotion organizations. No evidence that any other gun promotion organizations are involved in any insurance, illegality, or anything, and reconsider your risks and manage those risks. Take prompt action. And then she issues a press release that same day in which she says, cut your ties in order to manage your risk.
It's good that the ACLU saw the weaponization of government for what it is. Even in their counter-argument, Vullo's lawyer continued to argue qualified immunity, and even said that the NRA was attempting to weaponize the First Amendment and exempt themselves from the rules that govern you and me.
The government is more likely responding to conduct than, not speech, and 4 separate doctrines explain why. First, Iqbal held plausibility rules are, quote, especially important in suits where government defendants assert qualified immunity because they must be neither deterred nor distracted from vigorous performance by disruptive discovery. Second, the presumption of regularity is at its height. Third, absolute immunity protects enforcement actions. And fourth, causation is more difficult. That is particularly so after Parkland, which led many businesses that Ms. Vullo has no control over, such as United Airlines and Avis Cars, to sever ties with the NRA. Were this court to accept this thin complaint in the teeth of the conceded illegal conduct, it would empower strike suits to enjoin valid enforcement and open sensitive discovery. That's why the court's traditional test here is right. A government official crosses the line from coercion to persuasion when, 1, when they are threatening as opposed to encouraging, and 2, there is no objectively reasonable basis for their action. The NRA can't meet that test, and that's why they are seeking to weaponize the First Amendment and exempt themselves from the rules that govern you and me simply because they're a controversial speaker.
But thankfully, SCOTUS decided 9-0 in favor of the NRA. The opinion, written by Justice Sotomayor, held that Vullo violated the First Amendment by coercing regulated entities to terminate their business relationships with the NRA in order to punish or suppress gun promotion advocacy. The case now returns to the lower court, but essentially the victory's in hand thanks to the SCOTUS framing. Now you could be saying to yourself, I'm glad that's all over. Well, as we know, anti-gun groups never really stop attempting to restrict your rights through whatever means necessary. GOA's been fighting in Congress on this issue for a long time and will continue to do so. Here are some great pieces of legislation we currently support. The No Red and Blue Banks Act and the Fair Access to Banking Act are both great examples of clear law that would prevent someone like Marie Vullo from ever being able to use her regulatory authority to crush gun groups. GOA has also been fighting in Congress against the Safer Banking Act. This Trojan horse was mostly about allowing marijuana industry companies to access federal banking infrastructure, even though they sell a product that is federally illegal. In the bill itself was a so-called Operation Choke Point fix from New York Senator Chuck Schumer, which actually did more to facilitate the debanking of gun companies than anything else. We raised the alarm about this right away. Viewers might remember a Minuteman Moment episode where we cover the committee hearing about how bad that bill was. And thankfully, GOA fought against that bill. Listen to this reporting from Politico. The effort hit an unexpected snag in May when a compromise rattled the bipartisan coalition around the bill. It prompted Gun Owners of America, a nonprofit advocacy group, to blast the legislation as a threat to gun stores. Senate and House Republicans began to speak out, leaving GOP backers like Daines and Senator Lummis scrambling to shore up support on the right. Sinema, a Senate banking member who worked closely with Republicans when she was a member of the House Financial Services Committee, has jumped in to smooth things over. But that didn't work out. So instead of passing the bill on its own, anti-gunners tried to throw it into a must-pass Federal Aviation Administration reauthorization bill a few months ago, but we killed that too. Thanks in part to the work of our team in Washington. FAA reauthorization came and went without the Safer Banking Act being attached. And because we stopped Congress from rewriting the law while the case was pending, now Schumer can't undercut the Supreme Court's decision. Now we can go and use this SCOTUS ruling to defend ourselves and the firearm industry from debanking and use it to hold bureaucrats accountable without a watered-down fake protection written by the Democrats. So that's why it's so important for GOA to fight for your rights in Washington and in the courts. Thanks for watching. I'm Phil, and this has been Law and Ammo.